The last side of lobbying, the courts.
Finally, we should discuss the site for the final stand of organizations that have played the lobbying game in the legislative and executive branches and lost at both battlegrounds. The U.S. judicial system and the courts can be the final site for protecting your interests. Most people do not think of the courts as a site for political battles, but they clearly can be and often are. We also know that legislators and bureaucrats often make decisions that violate existing law and even constitutional law. One good example would be the aforementioned proposed city ordinance regulating lawn signs for realtors. Such a law could easily be a violation of the First Amendment's protection of the freedom of speech, and in this case, commercial speech. Unless you are a huge corporation or powerful national association, you probably do not have the resources to pursue a case all the way to the U.S. Supreme Court, but there are ways to play the judicial lobbying game on the cheap. A corporation or association can file a suit challenging an ordinance, law, or regulation. That is the costly version of judicial lobbying because it may cost hundreds of thousands of dollars. A much less costly form is to file an amicus brief in an already existing case. This piggybacking onto another case is very common, and some cases will end up with dozens of amicus briefs seeking to add their wisdom and reputations to a cause. Another recent form of judicial lobbying has been the financial activity of corporations and groups in elections involving judicial selection and retention. Especially at the state Supreme Court level, elections have attracted millions of dollars from interests seeking to influence the judges who may have to vote on issues and interests that impact the corporations and interests in the state. This lobbying tactic has always been possible, but has become more often used in recent years as the costs of even judicial elections has risen in the world of electronic campaigning.